Thanks very much, Dixie. It's an absolute pleasure to be here in person after the last 2 years of virtual, and the view certainly has improved, and that includes the audience. So thanks for being with us. I've been asked to give as close to 2-sentence introductions for this panel as I can, which in a way is difficult given their achievements, but also easy given how easy it is to summarize them. Next to me is retired Chancellor Andre Bouchard, known to many of us as Andy. Andy's a Paul Weiss litigation partner now, but from 2014 to 2021 was Chancellor of the Delaware Chancery Court, which is to say the Chief Judge, where he issued many very significant opinions and presided over many significant disputes. He's been in legal practice focused on Delaware for 30 plus years, maybe 40, approaching 40, and we're delighted to have his insight on Delaware law and beyond. Next to Andy is Darren Robbins. Darren Robbins is one of the founding partners of Robbins, Geller, Rudman & Dowd, one of the most premier securities class action law firms in the world. And Darren is the lead lawyer there and as well-known and prolific plaintiff securities class action lawyer as exists. And we're delighted to have him with us and to have his perspective. He bravely has entered the den of largely corporate advisors to companies on securities law, and he's more than up to it. Next to Darren is my friend Jonathan Youngwood. John is a partner at Simpson Thacher and Bartlett, where he's been the longtime head of litigation. He's won every award imaginable for securities litigation defense, and is really a lawyer's lawyer and highly regarded by all. So it's a terrific panel with lots of perspective on these issues, and I thank them for being with us. So we're going to jump right into it. In terms of the topics we're going to talk about today, we're going to do a little bit on litigation filing and settlement trends, just to orient us. We're then going to talk about securities class action developments. John Youngwood's going to lead that discussion with counterpoints and points from Darren. I'll then speak briefly about SPAC litigation developments in the securities law area, and then I will pass the microphone to Andy Bouchard, who will talk about Delaware litigation developments, including as related to SPACs, but lots and lots of other topics. And we're going to close, and I really do want to save time for this, with observations from the panel, which are practical, that focus on the practical considerations that go into these litigations from all of our varied perspectives and thoughts on what comes next. So that's our agenda. In terms of securities litigation filing trends, and we were fortunate that Cornerstone Research, which puts out an annual report on securities class action filing trends, came out with their report last night, coincidentally, just before our conference and just before our panel, and we appreciate their support in putting this together. So stock drop class action complaints were flat year on year, which is to say there were 201 filed in 2022 as against 200 filed in 2021. I would note first that this is way down from the peak years. For example, in 2018, there were 400 securities class actions filed. And you may say that flat filings are interesting, given that stock prices fared much worse in 2022 than they did in 2021. There are a number of potential explanations for that. It's important, though, to think about not just quantity but quality. According to the Cornerstone report, one of the ways that they calculate the size of these cases is something called disclosure dollar loss. And by their calculation, 2022 was the year of the largest disclosure dollar loss of any set of cases, whether you average it or total it, which suggests that the cases were big. But even then, the sample sizes aren't that large, so one huge case can, to some degree, skew things. Before I go further, Darren, what do you make of these statistics in particular?
Well, the way they measure the magnitude of the cases, I think, is distorted by some cases involving companies like Amazon, which has a market cap that's extraordinary, and so declines in one company like that can really distort the numbers, and I think it has. I mean, I do think filings are up, typically when the water recedes. The emperor's clothes, or lack thereof, is exposed, and that's what's happened here. We have interest rate increases, including one very recent, 7 of them, I think, totaling over 4% in less than a year. and so, the market declines, I think, are reflected in these numbers. One thing in that report, and I just skimmed it, is the significant increase in the size of Section 11 cases. And I think you'll see settlement trends in Section 11 cases, which historically have been what I'll call fairly modest, usually high 7 figures, very low 8 figures. And I talked about this in connection with Cyan, where there was a lot of controversy as it went up to the Supreme Court. I viewed it as much ado about nothing, but in fact, this year the trend will continue, and Section 11 cases, 9-figure Section 11 cases, will start to come to the fore. So I think that that's something that is changing, notwithstanding the fact that IPOs in 2022 were down 95% from 2021, 95%.
A big chunk of the securities class action that were filed, a larger chunk in 2022 were in fact Section 11 cases. As we can see, they went up 40%. We think that's largely a function of the fact that 2021 was an IPO boom year, and usually the Section 11 cases come 6 months thereafter or so, 6 months to a year thereafter. So that was a big reason for 2021. We'll see on in 2022, Darren's prediction on 2023, you may see big cases. The volume may be down given the much quieter IPO market in 2022. Now, the 10B filings were down significantly in 2022. And one reason for that may be, believe it or not, there were less SPAC cases in 2022. And the SPAC cases have tended to predominate as Section 10B cases rather than Section 11 cases for reasons we'll talk about. Going forward, one thing that I thought was really interesting was 35% of the securities class actions filed in 2022 were either crypto-related, SPAC-related, or COVID-19 related. When you consider that those 3 types of cases essentially didn't exist more than 2 years ago, they're up to 35%. COVID-19 cases get dismissed more typically than other cases. This doesn't surprise me. My own experience has been judges are skeptical of cases premised on COVID-19 and companies' ability to have predicted them and the impact of the virus. Interestingly, issuers that IPO'd versus companies that came public via de-SPAC transactions were sued at about the same rate, which is to say about 16% of IPOs and 16% of going public transactions via de-SPAC resulted in litigation in the 3 years after those events. And then lastly, Section 14A cases, which are cases focused on shareholder votes, were down 50% in 2022. That may be in part explained by a slower M&A market relative to 2021 for sure. But the whole trend of these Section 14A cases getting filed in federal court, which is the only place they can be filed, to challenge merger disclosures, some would say results from an opinion issued by the former judge sitting to my left. And I wondered, Andy, if you could talk a little bit about the Trulia decision and whether you expected what occurred in federal court to have happened.
Sure. So let me attack it this way. Identify the problem, what the opinion hoped would be a solution or an aid to a solution, and then sort of how it's played out. The problem, and everybody probably lived through it who's in this room, is that by the time you get to around 2010, 95% plus of M&A transactions of any consequence in the public markets, 100 million or more, are being sued on regularly. A firm, or usually multiple firms, will file a case. They're usually trying to poke around and get some discovery through an expedited procedure. Their leverage is to hold up a transaction from closing, and if they don't like what they find out in their discovery, they can always try to settle it by doing curative disclosures, and in exchange get what the Chief Justice referred to in his talk yesterday that I guess Sam Glasscock coined as the intergalactic release. And that phenomena basically did impose a merger tax to do deals in, as I said, in just about every case. And the problems with that are that, number one, a lot of the disclosures that are allegedly correct are utterly meaningless. I remember very vividly sitting in my chambers with the law clerk one day and actually finding that 2 of 3 things that people were taking credit for as supplemental disclosures were actually already in the proxy, but nobody brought that to my attention. And one of the reasons that doesn't happen is you're in a settlement hearing, and this is totally non-adversarial. The defense wants to just go along, get their case done, and get a release. Plaintiffs, purport to have these disclosures that are worthwhile, and more often than not, they're really not worthwhile. And on the other side of the ledger, the consequence of the release can be meaningful. There are a number of cases, rural metro being one, and there are others, where but for an objection to a disclosure settlement, a case that had consequential financial value would have been settled and gone away and no more to be heard from it. And so it got to the point where, frankly, as a matter of corporate hygiene, I think, for the Court of Chancery, we wanted to take a position on that. And when I say we, I mean, obviously I decided the case, I wrote the opinion, but it is maybe the only case during my tenure where I affirmatively discussed it with my colleagues, made sure everybody was aligned on doing it, because if the court wasn't going to speak with one voice on this, it wouldn't be effective. That's the problem. So what's the solution? Well, just to be clear, you can settle a case for disclosures and get remuneration for it. But the point is, it's got to be like real additive disclosure that has some value and meaning. And so I coined the phrase that the disclosure should involve something plainly material, not to set a new standard of materiality, but it should be sort of obvious. Because any good lawyer, all the silver-tongued lawyers that would appear in front of me, can sort of argue about materiality and make it sound, oh, this little piece of information isn't there, and so on and so forth. And it's a very judgmental kind of call you have to make, and you're making many, many of these calls, because they're typically giving you 8, 10 different disclosures in a particular case, some additive input to a DCF or whatever it may be. But the key is we made it clear to people we're going to scrutinize these much more carefully. And if and when you try to bring a disclosure-based settlement to the court, the release also would have to be proportionate. And naturally, especially I think with people that maybe were not really disciplined on how they file these cases, they fled to other jurisdictions. And I anticipated that would happen. And initially, the reaction was pretty good in the other jurisdictions. Many state courts either adopted or seemed to follow Trulia. New York was a great exception to that. It went a very different way. Federal courts were doing so as well. And then something I didn't totally expect would happen is that it turned into really a mootness process. The Trulia decision I wrote actually discussed that mootness would be an okay to resolve these kind of cases. And when I say mootness, I'm talking about the difference between when they settle, they bring it to court and the court approves it, and you have a court order with a settlement, with the release. As opposed to simply mooting the claims and then seeking a fee that the company in its business judgment can decide to pay. They're not getting a release, and they can just make a business judgment that it's appropriate to pay. But in Delaware, going back to 15, 20 years ago from the great Chancellor Allen, you have to make disclosure. The company that is doing the paying, which is usually the acquirer, has to make disclosure of that payment, so there's some sunlight on the process. On the other hand, in the federal system, there's no sunlight, and that I didn't foresee. And unfortunately, that I think has, in my judgment, been sort of a failing, if you will, of it having sort of more of an enduring effect. But if your numbers are right, that's actually encouraging in terms of the aggregate numbers.
Yeah, no, and certainly Chancellor Bouchard took care of his side of the street, and we'll see what the federal courts continue to do with theirs. I'm going to move ahead to settlement trends just very briefly, and this is a credit to the Duane Morris class action review as well as Forbes. Securities fraud class action settlements totaled $3.25 billion in 2022, which was an 80% increase over 2021. Again, those kinds of changes can be driven by one or two cases, so they can't necessarily be thought to show a trend. I thought it was interesting to look at the 10 largest. If you look at the companies, you've got a really wide scatter of industries. There's no predominant trend from just looking at the words on the page. They span lots of disparate industries. I was wondering, Darren, just quickly, if you've got any perspective on what it takes for a case to end up on a top 10 list, and those are obviously cases that you go after. What's different about cases like that?
I don't understand exactly the question. I will note that the numbers here are modest. The last 2 years, each of the largest recovery had been over $1 billion. Here, the largest was 800, although the number of 100 to $200 million cases is what drives the number. These add up to about 2 of the 3 billion.
Yeah.
And, you know, there were a good number of $100 to $200 million. And like you said, they are across industries. I look at things like, you know, BlackBerry was at trial. Walgreens and Granite Construction were meaningfully litigated. Novo, meaningfully litigated. Stamps was a case of ours, as was Novo. I mean, they look like a pretty, you know, wide swath of securities fraud cases. And there's nothing in this report that really stands out as dramatic. It seems like an average year. I don't know if that's good or bad. I note that there was 200 cases filed, which again is about average going back 30 years. And this, you know, 3 billion is high, but typically we see between about 2 and 4 billion, with outlier years being 5+, and there's been 3 or 4 of those. So it just seems to me like, other than some of these cases going a little longer than usual, like Teva, Twitter was on the edge of trial. That's probably the only thing that stands out to me on these cases.
John's going to talk about securities litigation, and he's got a number of topics he's going to shoot through and give you a sense of those with input from Darren. John, take it away.
Thanks. So we're going to kind of do a mad dash through what I think are either a hot topic where there was a development last year or likely to be a development this year. And on that front, we start with the Slack Technologies case, which is scheduled to be argued in front of the Supreme Court in April, coming out of the Ninth Circuit. The case arises out of the direct listing context, which before 2018 really couldn't be done. And so you have new practices clashing with old law. And the old law that this clashed with is the general agreement among the circuits that in order to bring a Section 11 or Section 12 claim under the 33 Act, you've got to trace the share owned by the plaintiff directly back to the registration statement that you're purporting to claim contained a material misstatement or omission. In a direct listing case, you're going to have shares that can't be tied in the traditional tracing way to the registration statement itself, even though there is a statement out there. And the Ninth Circuit, in a 2-to-1 decision, ruled, I think, more looking at the spirit of what they thought the 33 Act was about than the actual literal language of it, that, frankly, good enough, and that but for there being a registration statement on file, you couldn't have had the shares that went to individuals, even if they weren't bought pursuant to the registration statement. So it's an interesting case, interesting to see if, when the court rules, obviously which way, but also interesting to see if the way they rule ends up affecting things other than just direct listings.
Yeah, one possibility there could be after IPOs, when shares come out of lockup that were not registered. This is one of the arguments that was made in the cert petition. You know, could that end up being a situation where it cuts off an ability to have Section 11 standing? Darren, what do you think is going to happen? Are you able to comment on that?
Well, I just think, you know, we up here play inside baseball, but the reality is this case reflects bad facts make bad law. And what the court recited, interesting enough, this decision, as we talked about earlier, was penned not by a circuit judge, but by a judge sat by designation from the Court of Trade. So that, the International Court of Trade. Why is that significant? It's significant because somebody who's not well versed in this area was offended by the conduct. They were offended by the conduct because throughout the decision it cites all these public statements by certain professors and certain defense lawyers saying this is the way you evade liability. You manipulate the securities laws to evade responsibility for issuing false statements in connection with the direct listing of shares. And so the rationale that the court used, which is pretty solid, that none of these shares would have traded without the registration statement, and therefore you have traceability. Historically, I agree with my colleagues, the courts have applied a standard that's so stringent somebody can be put to death at a lower standard than establishing traceability. Does that sound preposterous? It's because it is. 100% you have to plead and prove traceability historically. So this stunned my friends here when they saw this practical decision, and I understand why. I think the other good point or important point about this decision is it was joined, the majority was joined by the chief judge. So it was penned by a judge sitting by designation, but the chief judge, who's very well respected, very middle of the road, said, you know, this is a solid rationale for people who try to evade the securities laws. And so I think it's solid and good. What the Supreme Court will do, I'm not going to dare to predict.
No predictions. Stay tuned. Tune in June. So let's touch on scheme liability. It's like, it seems every year there's a Supreme Court case that we talk about it's coming, then we talk about what it means. And Lorenzo was such a case in 2019, and frankly before that, because Lorenzo really follows on the case of Janus, was Janus. Janus basically held that to be liable under Section 10 under the 34 Act, you have to have made the statement, and it had a very narrow definition of what to make means. Lorenzo comes along later. It's in the context not of a private action, but an SEC action, and at least to some of us, at least on the defense side, we read it and we think it erases much of what Janus was, because it starts talking about in the context of a statement, because the issue in Lorenzo was a statement that was written, made by one person, and then disseminated by another, and the court holds that there can be liability tied to that dissemination under Sections A and C of Rule 10b-5. You've now had a number of circuit courts that have started to look at Lorenzo with somewhat different interpretations. We put two up on the slide. And the real question is whether or not you can have a Section A or C claim, an A or C scheme type claim, that is also directly tied to a statement, or if you have a statement, isn't that more properly analyzed under a Section B claim? I think most of the defense bar would argue that it should be narrow, and if it's a statement, analyze it under B, but you've certainly got some courts out there that are reading it more broadly.
And interestingly, if scheme liability finds its way back to the Supreme Court, none other than Justice Kavanaugh, when he was a D.C. Circuit judge, in Lorenzo itself dissented from what ended up being the holding. So it's interesting to follow. Darren, how often are you resorting to 10b-5A or C as opposed to good old 10b-5B?
Well, I'm not so bold as to assume that everybody listening is a securities lawyer, litigator, so I will just say that the statute and the rule have historically been implicated in securities litigation through one subsection which prohibits false or misleading statements. But there are other sections which basically prohibit a scheme and a wrongful course of business to defraud people. And what we're talking about is those, and whether new life has been kind of breathed into these provisions. And starting with Alphabet, which I call Google, there's the judge there, again, it's really important. This is a former O'Melveny and Myers lawyer, a Republican appointee, very careful, thoughtful jurist, wasn't having it and said, you know, this was properly alleged to be a scheme to defraud, and the statute and the rule mean what they say, and you don't just have to plead false statements. And so there's been a number of cases we've had. I'd say in the last 3 or 4 years, we've probably had 10 or 12 cases involving a scheme to defraud. I think they're separate and apart, these provisions, and they overlap. And I think the securities laws, as we all know, were adopted to address the largest meltdown in our country's financial markets, and they were designed, as the Supreme Court has said multiple times, to be flexible and address underlying misconduct. And I think these decisions reflect that fact. And I think that, you know, scheme allegations, as you mentioned earlier, we were talking about Enron. I mean, it was a scheme to defraud. Did it have false statements? Yes, but there was all kinds of off-balance sheet manipulations that didn't turn on affirmative false statements to the market, but rather a pervasive scheme. And that is a viable theory, and I'm glad that the courts have ruled the way they have.
And yet in Enron and then in Stonebridge, the Supreme Court rejected liability for schemes, for secondary actors at least, because the cases were premised on ultimately a misstatement to investors, and there couldn't have been reliance on a secondary actor. maybe we'll come back to how that can be reconciled with Lorenzo, both
I'd be
Supreme
glad to
Court
address that.
decisions. Short seller reports.
Short seller reports. So I think it's something like 15 to 20% of securities cases that are brought are keyed off of a short seller report. And so, right, what's a short seller to do? A short seller is trying to make money by shorting a stock and therefore has an incentive in reports that they publish to tell a negative tale about the stock. They tell the negative tale, and sometimes the market listens and the stock drops, and then sometimes a securities case follows. The question is whether or not that short seller report, which is not a statement by the company, but has negative sentiment, I'm going to say, about the company, whether that can be sufficient under the securities laws to trigger loss causation and to satisfy the element of loss causation, which generally speaking requires that there be some correction of a statement that the company previously made or an omission that the company previously made, and then the correction tells the market what they said before isn't true or isn't the complete story, the stock drops. In the short seller context, it's not the company speaking, it's the short seller. And generally, the short seller is basing its statement on something that's already public, right? Because the short seller isn't part of the company. And so the question is, can something that my opinion, Darren's opinion, anyone's opinion about the company, even coupled with analysis of public information, constitute a corrective disclosure when, if you believe in efficient markets, all that person's doing is analyzing what's out there. And a number of courts have said, if that's all they're doing, if all they're doing is regurgitating, doing analysis on stuff that's already out there, it can't be a correction. You haven't satisfied loss causation. The Ninth Circuit has come up with a quite complicated two-step test that doesn't draw quite as bright a line and basically allows, in certain circumstances, if the short seller has some way of analyzing information that the market as a whole couldn't do on its own, or you can show didn't do, that could be enough to constitute a corrective disclosure and allow the case to go forward.
If that sounded like a game of Twister, that's what it is. I mean, it's unbelievable what loss causation has devolved into. But
That emanates from the Supreme Court's decision in Dura. But Darren, aren't short sellers basically antagonists of your clients? I mean, they're trying to drive the stock price down. Your clients own the stock.
I don't know what they are. I mean, they're market participants. What I do know that every time I hear someone scream, an issuer scream about short seller reports, I usually wait about a year and the company's blown up. And I mean blown up like old people say blown up, not like 20-year-olds. Not up, but blown apart. You know, it's gone. You know, the company's stock has declined by 50 or 80%. The most recent one that comes immediately to mind is Valiant, how they went after the short sellers. The short sellers were full of it, of course, and then that company, well, most people know what happened to that company. It happens time and time again. So to me, you know, the securities laws recognize this concept, like, for example, you can be literally truthful, but if you mislead, it's actionable. The buried fact doctrine, you can have a piece of information buried in a 500-page 10K, and if it's buried in one line in a footnote, that might not be enough. So to me, if it's, and I think this is reflected, there's a case called First Solar in the Ninth Circuit, which basically says loss causation should follow a pretty simple proximate cause approach, you know, that we learned in law school. And so this is an attempt by a very smart jurist to try to make sense out of this, because of short sellers, you know, they do have a different agenda, and sometimes they themselves are manipulative. There's no doubt about it. So, but this kind of contorted analysis is hard for me to follow. I went to public school, so I like simple rules.
We'll let you have the last word on that, Darren. ESG. Yeah.
You need a straight man so that you can have a Darren. Just so I am playing my role here. I'll go real quick on ESG, and I know we have one more topic in this area. So, look, ESG covers a host of areas that can rear their heads in securities cases. We've listed safety issues. There can be environmental issues. You can have workplace harassment. You can have really every aspect of what we are now, you know, looking at and focusing on in many corporations from a governance perspective are focused on in ESG. I think the truth is that they're really all quite fact-specific and in some ways no different than any other securities case. What it takes is some tie to a statement that's really a hard statement, not some soft generic statement that a company's making that ends up being corrected later. And it then fits really quite well into the rest of all the rubrics of securities litigation. So, final topic in this tour of recent developments are federal forum provisions. Adam started and Darren commented a little bit on where are the Section 11 cases being filed. And I think if you had gone back to 2018 when Scion, which was a Supreme Court case, was issued, which basically resolved uncertainty and a difference in how both state courts and federal courts on at least the two coasts were treating it, said that Securities Act cases, 33 Act cases, can be brought in federal court, they can be brought in state court, and that was one of the issues, could they be brought in state court, and they're not removable to federal court, because it would be no good to bring them in state court and then allow the removal. I think a lot of us thought you'd see a whole lot more state court litigation, but the statistics that Adam showed show that most Section 11 claims are now being brought, I think it was like 2/3, are now being brought in federal court, notwithstanding Scion. And what's the reason? The reason is that just as the law changes, facts change, and then people react. And what's happened is companies have reacted and put in forum selection provisions in many charters and bylaws that require Section 11 cases by that company's stockholders to be brought in federal court. And what's then happened is starting in 2020, the Delaware Supreme Court allowed that to go forward, and a number of state courts have followed. And I think that's really the reason that you're seeing so many Section 11 cases in federal forums, and I suspect the number will continue to grow.
And interestingly, the cases now that you see in state court are predominantly situations where the company's not a Delaware company and therefore doesn't have a similar bylaw or charter provision. Some companies are, that are, for example, foreign private issuers are thinking about or putting these into their ADR depository agreements as a way to have a forum selection clause there, and things of that nature. But that's essentially the gap. Some investment grade companies that didn't think they needed it because they wouldn't be doing an equity raise have fallen through the cracks as well, but it's fewer and farther between. Darren, you've already said you think it's much ado about nothing. Still your view?
Well, it is, but it's preposterous. It's like me deciding that if I do something to you, you have to bring a case on a Tuesday, in Zimbabwe on yellow paper. I mean, the notion that a corporate director can decide where he or she's going to be sued by inserting into bylaws is beyond preposterous to me. But if my partners let me file complaints, I'll file them in the jurisdiction I think that's appropriate in consultation with my client. And we will continue to test this, but certainly, there's a more practical problem with state court is that typically when I litigate a case in state court, I create leverage, and then somebody comes along in federal court and says, thanks for the leverage, and gives the case away. It's the concern about race to the bottom, which, has been an issue you contended with when you sat on the Chancery Court. And it's an issue that is always one top of mind for us, is to litigate a case and then have someone else come along and kind of use that leverage. But each case is its own, and I file many in state court and many in federal court.
I'll just say quickly in defense of directors, one, I don't think it's entirely preposterous to ask shareholders to invoke a federal statute only in federal court. And secondly, as you pointed out, in many, many cases, companies find themselves sued in state court only to have a federal court case alleging the exact same thing come along. Duplicative litigation, not good for anybody, especially companies.
I have to respond 1 second. I just must. I with all due respect to directors who I respect and admire, I must say that the U.S. Congress and the President of the United States signed a bill which said you could do this. So for individuals to override that, and the Supreme Court, of course, endorsed it 9-0. We were taken up and we won that case 9-0. So again, with all due respect, I have a different view.
This is not, my screen's not advancing.
We're stuck on federal forum.
Yeah, sorry.
There's something Freudian in that.
That's okay.
What could be more exciting than to talk about
Right.
which court
I
you're going to
apologize
litigate?
to jump forward. This one's not advancing for some reason.
That's too bad. So I don't want to read it. There he goes.
Okay, great. Yeah, so very quickly on cryptocurrency. This panel decided we were all too old to explain cryptocurrency, so we're going to stay on it. We're going to be very, very succinct. To me, lots and lots of cases being filed, really no circuit level decisions, so we don't really yet know what the law is going to be. Biggest issue is probably what is a security? Is it a security? And that issue, which many of us as securities litigators didn't encounter since reading about Howey in law school, is becoming more topical. In addition to crypto, the Second Circuit's going to hear argument in March on a question of whether Term Loan B is in fact a security, and that's the Millennium case, which is one to watch. So this issue is, I think, going to get some circuit level guidance, at least in the context of leveraged lending and maybe cryptocurrency soon. Regarding SPAC litigation, I'm going to be very brief on what's happening in federal court on SPAC litigation, and then I'm going to pass it for the balance of the discussion to Andy. It's a big portion of the cases now, not surprising given the massive, massive boom in SPAC transactions that happened in 2000 and 2001. With that market gone almost shut during 2022, I think the litigation is really going to taper. The types of claims that are brought, for some reason, lots and lots of these cases relate to electric vehicles, and a lot of the more better known ones. In terms of the cases that are brought, you can have 10B, you can have 14A because the shareholder vote's involved. You have, generally speaking, the focus has been on de-SPAC transactions, not the SPAC IPO. You've got an interesting set of defendants. Not only would you have the issuer and the issuer's D&O, but you often will have SPAC sponsors, former SPAC directors, and sometimes investment banks and auditors thrown into the mix. The really interesting legal issues haven't really been addressed, certainly at the circuit court level. One is, in particular, does the PSLRA safe harbor apply to projections in the context of a de-SPAC transaction? We know it doesn't apply to IPOs. Strictly speaking, we're not talking about IPOs. There's a proposed SEC rule on the subject. More on that in a minute. But no decisions really on that issue yet. Similarly, investment banking liability has not been well defined. One case, Waiter had an opportunity to delve into some of those issues, but determined there was no misstatement at all, so those issues were not reached. The other thing I wanted to mention very, very briefly is the proposed SEC rule, which probably most of this audience is familiar with. Back in March of last year, the SEC proposed comprehensive rules related to SPAC transactions. Many blame that proposal for the shutdown of the SPAC market. Certainly economic conditions played a role as well. Lots and lots of elements of the proposed rules. The two that are most relevant to securities litigation are the safe harbor point that I mentioned already. Remembering that de-SPACs and SPAC mergers are marketed principally on projections in most cases. That's in contrast to IPOs, where projections are not put out. Whether or not that safe harbor applies is important because that's the essence of the disclosures. And then there's this issue of underwriter liability. There's proposed Rule 140A, which would make SPAC IPO underwriters that participate in the de-SPAC transaction potentially liable as underwriters on Section 11 in the event that they engage in certain roles. That principle is untested. It remains a proposed rule, and some would argue inconsistent with Second Circuit authority, at least in particular the In re Lehman Brothers decision that addressed credit rating agencies' roles in putting together RMBS and non-distributional activities. So that's a quick look at SPACs in federal court. And on the federal side, I'm now going to pass it to Andy to hear about Delaware.
Just advance the next slide.
Sure.
So actually, unlike the federal situation, I guess, there's actually been a fair amount. There's only 2 cases, but a fair amount of the issues have been explored in a couple of cases that define SPACs from a Delaware law perspective. And I just wanted to start for 1 minute to sort of lay out a basic structure. This is mostly from Multiplan. Most of them are very similar because it's critical to sort of put your finger on, what's driving this. The analysis in the Court of Chancery, and it's follow the money. You just follow the money and you get the conflicts and you find out these things are just sort of riddled with conflicts. Now that can be changed, but the way it's been practiced to date is just riddled with conflicts. The key is that you have a sponsor whose responsibility is to identify a company to then take public through the SPAC vehicle. and make that acquisition, but they get compensated differently than the public shareholders. So how does it work? They'll typically get a different class of shares, typically the Class B, which is their promote, and the Class Bs are convertible into the normal public company stock, the Class As, upon the occurrence of a transaction where they acquire an operating entity. They pay very little consideration, though, for that. Typically, they get about 20%, but the rationale is they're doing the work of finding a good business for an investment. But because they pay very little, and because they also get a lot of warrants, they don't have a lot of money at stake unless a deal happens. That's the key, unless a deal happens. Otherwise, there's no payoff for them. Whereas the public shareholders have a redemption feature. They have the ability, when the company's actually going to acquire an operating company, to get out of the deal. Usually it's at $10 per share. These all seem to be styled that way in their redemption right. They can redeem out, leave the scene, get a little interest on their $10, go home. So they're differently situated than the sponsor. And it's that conflict that really has driven the Court of Chancery's analysis in these cases. And they just flip to the next one. And there have been really two cases. One is Multiplan, which is like some sort of health benefits company. And the other one is Gig 3, and I'll show you in a minute what sort of the claims that actually survived. These are both cases that were handled by a fairly young judge. Judge Lori Will, I mean young in terms of young period, but young in terms of tenure on the court. She just joined the bench about a year and a half or so ago. And what are the key issues that happened in this case? I'm not going to go through all of this, but the theme is, as Delaware usually attacks issues, we typically apply just typical traditional fiduciary principles to look at a problem. And she had to clear sort of the underbrush about some arguments in terms of should we deviate from a standard fiduciary duty analysis. And the first key argument that was made is that the cases should be looked at as an overpayment claim, that somebody overpaid for the target that they acquired. And she rejected that. And that's a critical point, because if it was viewed as an overpayment claim, that would be a claim where you would analyze, if a derivative case was brought, the independence of the board at the time of filing, which would be the independence of the board that's the operating company, not all the people that are actually involved in the SPAC itself, where all the conflicts exist. Because the operating entity post-SPAC is typically your normal public company board, majority of independent directors. You could do an independence analysis, and you're probably going to get a dismissal of a derivative claim if you have a truly independent board, because you wouldn't be able to demonstrate demand futility. So the first thing she says is this is not about an overpayment claim. Why isn't it about an overpayment claim? Because the public company shareholders are differently situated, and the relief that's warranted is relief that's specific to them. And it's a direct claim in both these cases for getting good disclosure so they can make an informed decision about whether to redeem or not. It's like shareholders getting information in a standard M&A case where appraisal rights exist, to have the information necessary, which is a direct right, an individual right, to get appropriate information to exercise that decision. She also dealt with saying it's not a holder claim. I'm not going to really get into that right now, since we'll probably use up too much time doing it. But once she gets rid of that stuff, and also an argument that it's really all contract, and there's a place for fiduciary duties, then you're dealing with the playing field of applying normal, traditional fiduciary duties. And this is where the conflict is critical. In Delaware, we attack things by looking at, we're applying a standard of review, which is often based on, who has conflicts, or are there conflicts? Are people engaging in self-dealing, or is there the potential for that? And if you look at the second bullet down, this is the key thing. The sponsor is differently situated because they're incentivized to do a deal, even if it's not going to yield the $10 a share redemption value for the public holders. I'm not saying they intentionally set out to do this. They're probably looking for really good companies, but they're also on a clock. And if they don't do a deal before their clock, the SPAC goes away. They have to return the money. And so they may want to do a deal, and it's economically rational to do a deal, even if it may only yield $5, $6, $4 of value, whereas the public holder logically would only want to do a deal that yields for that public holder $10 of value. And because of that conflict, you have a situation where there's a rub. Now, you also have to look at it from the standpoint of, is that a conflict that can be addressed through some business judgment analysis because there would be appropriate deference paid, or should be addressed at a higher level. And in both circumstances, the court found that both there was a controller involved and the control was conflicted, which is one basis to apply entire fairness review, and that the board itself was riddled with conflicts and entire fairness review was warranted. And in the first, multi-plan, it was very simple. The sponsor had the absolute right unilaterally to appoint and remove all directors. It was as if, even though he only owned 20% of the shares, he was a 51% or higher shareholder. He had total control, was a poster child for control, and he had the conflict that I just mentioned before in terms of incentives relative to the public holders. And what often happens with the SPACs, at least early on, for sure, is it's the ultimate friends and family program, that everybody that's on the SPAC board has a relationship, usually sits on like a director carousel, does multiple boards with sponsors. In the case of multi-plan, the sponsor's brother's on the board. In case of Gig 3, the sponsor's wife's on the board, and their friends. So there are all these conflicts as well at the board level. So in both cases, both grounds, conflicted controller, conflicted board, you're going to apply entire fairness review, which is going to be a high level of scrutiny. And then you want to flip to the next slide. And then when you really get down to the nitty-gritty of what the actual issue was in these two cases, it's interesting you were talking about short sellers, because multi-plan was the victim of a short seller report. Muddy Waters did a report on them, and this happened just around the time of the closing, I think. They didn't bring this case pre-close, but they brought it after the deal closed. The Muddy Waters report basically said, oh, the proxy did not tell you that your largest customer, United Health Corporation, which owned about 35% of multi-plan, was looking at a solution that would basically make your product at multi-plan useless to them, put you out of business with respect to your relationship with multi-plan, which would be a serious claim if it's true. And of course, there was some litigation. It passed the motion to dismiss because of all the conflicts I mentioned. It was in litigation, and that case is now settled, or there's a proposed settlement the court has to evaluate for around $33 million, which happens to be about the amount of the value that the sponsor who obtained an advisory fee for doing the transaction obtained for his advisory fee, just coincidentally. Gig acquisition, it's same thing. Disclosures are the issues in the proxy, because if you don't, with all these conflicts, inherently, you're probably going to be able to find a disclosure problem. It's just sort of built into the DNA of how these deals work. And the key ones here were, takes a little explanation on the first point, but the proxy statement in essence said, oh, your shares, you public holder, your shares are worth $10. But in reality, because of the effect of expenses in the transaction, because of the effect of dilution by the way the structure works, the real net cash that was in the company was only about $6, or at least that was the allegation. And the point was, well, the person who's going to sell a company is going to have the sophistication to figure that out, and therefore only be offering, in effect, $6 worth of value. And this person's being told in the proxy statement, oh, your shares are really worth 10. So that they're not being given the information to understand that wasn't a fair trade. They were, in essence, didn't have full clarity on what the appropriate return was for their shares. And there was a lot of, as you can see below, there was a disclosure claim as well, where they were touting the level of you can put projections in a SPAC, can't do it, if you're just doing a straight IPO. And they have projections in here saying you're going to get 22,000% return within a 5-year period, but never really gave disclosure about some other very basic information, like this is an e-vehicle company you were mentioning before. We get a lot of these in the SPAC area, and it makes very customized products that take a lot of time to make, and it just didn't have a balanced presentation. So both cases go forward. I think that might be the end of my SPAC.
Yeah, I want to ask Aaron one quick question. So on the core point that Andy was making about the SPAC cases, and in particular multi-plan, this conflict of interest between the sponsor and investors making the redemption decision. As the SPAC market evolved, you had transactions where, I think in many, if not most cases, the vast majority of investors were redeeming. So in some cases, you had 99% redemption. Is there anything left to litigate in Delaware in those cases, or do those cases go to federal court?
You're asking me?
Yeah.
Yeah.
So there is very little in those cases. We have a couple of 10b5 cases. The first SPAC case we brought down in Texas, it's going forward. It involves a company called Alta Mesa, and that case is being prepared for trial. I think we'll know within a year or two. I think the SPAC phenomenon is now at least over for now. We learned the first time in 1929 what it yields, blank check companies, and now we're in the process of learning again. Shareholders get left holding the bag, and I think that the phenomena has passed, and I think there will be some. I don't think they're going to be game changers. There will be some 9-figure resolutions. There'll be some more modest ones like multi-plan, and then that I think will work its way through the system. That's my take on it.
Great.
MFW. So I just wanted to discuss a couple things that were recent developments in Delaware on MFW. MFW obviously is the framework that was first articulated in a trial court decision by, I forgot if it was Vice Chancellor or Chancellor at the time, but Leo Strine, and that was affirmed by the Delaware Supreme Court, that sets up a basic model that if you utilize the two most significant protections for minority shareholders, namely the use of a special committee with truly independent people, the ability to have advisors of their choosing, the ability to say no to a deal, and exercise due care, and second, a vote that's fully informed by the disinterested stockholders and there's no coercion involved, that you can go all the way from entire fairness review and what would be the sort of prototypical conflicted transaction to deference with business judgment review. So that's the test. Just looking at the right side of the slide for a second, and there's some criticism, and Leo himself has an article out that has been construed to be some criticism at this point. It's actually being applied outside of the freeze-out context, so a whole series of other conflicted transactions as well, on the theory that if somebody goes through the burden, in a way, for a controller to put the most onerous protections in place, that it's appropriate to apply the same analysis in that circumstance. The only thing I want to cover beyond that is that there are cases on 2 of these 6 elements of an MFW case that I thought I'd focus on. The first is the one, number 2, which is the independence of the special committee, and I'm emphasizing the words committee for a minute, that I'll explain in a minute. And then the fourth is the committee satisfying its duty of care. So you can just flip to the next slide. So there are 2 cases here that, I don't know if anybody in this room remembers the band Meatloaf. I call this the 2 out of 3 ain't bad rule. Because the basic premise, 2 out of 3 ain't bad, nobody remembers this? Wow, I want you, I need you, but I'm never gonna love you. But don't be sad, 2 out of 3 ain't bad. Nobody remembers this? Okay, anyway, so this is the point of these cases is both had committees with 3 individuals on them. And in both cases, the independence of one was either assumed to be insufficient to be independent or found to be to lack independence. But because the other 2 were determined to be independent and the person who was tainted was not deemed to have dominated the other 2, the court said that's sufficient for purposes of satisfying MFW. The important point I would suggest is in the right-hand corner bullet, which is it's challenged on appeal. My view is I wouldn't bet any money that 2 out of 3 is going to carry the day here. MFW was really meant to be sort of this ultra-independent review situation. I could be wrong, and who knows, but I wouldn't bet money on it. I'd go conservative, make sure your committees are fully loaded up with independent people across the board. Then the next slide. And this slide really is, a very basic point. But the numbers sort of make you pause, but there's a very, sort of basic thing here. Controllers, they get to call the tune. So highest price wins in M&A transactions except for controllers. And that's really what this slide is about. But it's sort of interesting how it unfolded. The controller, I guess it was Bridge Bio, wanted to acquire the balance of the shares. Ultimately it goes through a process. It's pre-set up with MFW because it has to be preconditioned in the first place before you do your deal. The structure's in place. Everything about the structure seemed to be working correctly. They bid him up a little bit. He ultimately I'm characterizing an entity as a he, but BridgeBio ultimately gets a proposal accepted by the committee at $73 per share, roughly. And, that's the story, except now an unsolicited bidder comes along in GlaxoSmithKline, and they offer to pay a substantially higher price, $120 per share, and I think they even indicated they'd be willing to pay more if the committee would engage with them. And the critical point here is there's one thing I think is sort of interesting about this, which is the standard in that context with the no-shop, the standard no-shop provisions you have in the agreement, is that the committee couldn't engage with an unsolicited bidder, which GSK was, unless two things were shown. One is that the unsolicited proposal could be reasonably expected to be a superior proposal, and that the failure to engage with it would be a breach of the special committee's fiduciary duties. Now, what's interesting to me about that is if you recognize the basic principle that's in the next bullet and accept it, which Delaware law does, you could see yourself advising, oh, well, we just can't consider this because we're never going to be able to yield a higher proposal because he has all the bananas and he gets to call the tune. He doesn't need to sell this company just because somebody comes along with more money. And therefore, necessarily, that wouldn't be a breach of duty. You could look at it that way. It wouldn't be totally illogical. But the board was advised, and this is where just practical reality sets in, the board is advised by its lawyers that that standard was satisfied, and indeed you could engage, and they do engage. And after they're done engaging, of course, it ends up right where you think it's going to happen. They can't move forward. The controller won't cooperate. Deal gets done at the price the controller proposed, $76. And in the MFW analysis and the motion to dismiss, the court then looks at this and says, well, the fact that you did this, engage, said that you could engage and have the discussion, was further evidence that made clear that the committee did exercise its care, didn't act in a grossly negligent manner. I thought that was the only sort of interesting point.
So takeaway from that then that everybody should have that in their merger agreements in these circumstances?
Well, that merger agreement provision is very standard.
Yeah.
The issue really is deciding that even though something might appear futile, right, that nonetheless, we're going to trigger that and engage, which is totally logical from the standpoint of even though you 99.9% odds, the outcome is going to be the controller is going to block anybody else doing anything else. But making that effort is just a better record to get your MFW protection. And what am I talking about next? Caremark, okay. And on Caremark, everybody I'm sure knows about Caremark, but in the 10-second nutshell, this is Delaware's oversight jurisprudence, which has been sort of in full bloom since around mid-1990s when Chancellor Allen wrote the Caremark decision. Wrote it in the context of settling a case. It was a lot of dicta actually in the case, but it's critical now. And there are two really basic claims in Caremark. One is the claim that you need to have reporting systems in place. And if you didn't have a reporting system in place, that could expose you to a challenge. And the whole idea is to get material information about sort of mission critical things to a company elevated to the attention of the board. They have systems to do that. And then the second logical step in that is that if and when a problem is brought to the attention of the board, the proverbial red flag, that you don't just ignore it, that you take appropriate action in response to it. And in both circumstances, Delaware law has now evolved to make very clear the standard that's applied to that is a standard of bad faith, which is a scienter-based, subjective-based standard in Delaware. So what's interesting is that from 1996 till about 2019, there were probably less than a handful of cases that ever got by motion to dismiss. These are the notoriously hardest claims to prove. And then all of a sudden we had a period of time that changed that dynamic from 2019 to 2021. And why don't we flip to that? So we then have a series of cases that really get kicked off with Marchand. And I'm not going to go through all of these, but frankly, these are some pretty egregious cases that changed the circumstances, or I should say that changed really the outcome of getting a number of cases. These are 6 different judges in a 1.5-year span denying motions to dismiss, or in one case reversing the granting of a motion to dismiss to allow a Caremark claim to proceed. That's a sea change from the prior 24 years. And why did this happen? I think because of some pretty ugly situations. I mean, Marchand makes one product essentially, ice cream. It's a monoline company. It has a listeria outbreak and people die. And basically, and there's a quote there, it's a failure to implement any system to monitor food safety. Pretty egregious. Go down to the second to last one, and it's a circumstance where AmerisourceBergen is making an oncology drug, and for a 13-year period, these oncology drugs have a load, I guess, in the syringe, and they always have a little extra, this called the overfill, because you could lose some of it in the injection of the drug or in whatever it may be, but it's deliberately done that way. And for 13 years, somebody was skimming off the overfill to fill other syringes and try to make more money. And this is a red flags case where there was an audit committee report on this. There was a whistleblower involved. There had been an FDA search warrant looking for information on this. Again, pretty egregious facts. And then, of course, everybody, I think, has seen Boeing, another pretty egregious circumstance where in the MCAS crashes that occurred, the record reflected there was no, and I want to emphasize the word regular because it wouldn't be fair to say there wasn't safety reporting. There clearly was some safety reporting, but there was no regular board level reporting, and therefore the case was allowed to proceed. So if we go to the next slide, you can just see on here, I just sort of categorize the cases. It's astounding to me, really, the first category could happen to any sizable public company, that there wouldn't actually be a reporting system in place, because it doesn't need to be perfect. It's just, you just need to show you tried to have a system. And then the other 2 involve sort of the red flag situations. And what happens with these cases? To my knowledge, none of them ever gone to a trial where liability has been proven, ever, in Delaware under Caremark. Maybe there's a trial where somebody lost. I don't know that, but I don't think there's any post-trial judgment. So typically, if these motions get denied to dismiss the case, one of 2 things happen. People settle because the plaintiffs have leverage, or they appoint an SLC to then take up the case afterwards, which has sort of been the outcomes.
Yeah, one thing I wanted to ask Darren, because the Caremark claim had previously been the Mount Everest of, the hardest thing to plead and prove, have these cases changed the dynamic in negotiations, whether it be, issues with insurers and Side A coverage and this sort of changed paradigm, or is it just bad facts, bad law?
Well, I think that this has to be looked at in combination with the jurisprudence in Delaware on 220 actions, which gives folks access to information that historically they either didn't believe they had or didn't have. And so I think that is in part tells the story. I don't think there was never any bad facts prior to 2019. And I do think it creates a lot of leverage. What it's done is driven the insurance companies crazy, because this is the second time in my career where the insurance companies, starting about 5-6 years ago, have faced these dramatic obligations. You saw in the Boeing case, $237 million. The vast majority of that was felt by the Side A coverage. Side A coverage was, if you're not familiar with it, directors and officers, was sold as typical insurance policies are. We'll collect premiums and we never pay any claims. There was no set of circumstances where they expected to pay out anything meaningful, and now you have these kind of payments. The other one was back in the old days on the ERISA claims, where they would sell policies, $50 million policies, and pay $200,000 claims. Then all of a sudden Enron came along and they were like, oh my gosh, and paid multi-$100-million claims, actually paying out, which insurance companies always love to avoid or evade. Anyway.
Maybe just flip back to Caremark. I'm going to talk about balance just for a second. Yeah. So I just wanted to say one other thing on Caremark before we go to that next slide, which is, so after this series of cases, which I think goes till about October 21, and you go forward, there were 6 Caremark decisions. It's sort of I guess from the defense perspective, the ship had righted. There were 6 dismissals of Caremark cases, and there hadn't been another one that sort of followed this path in about a year and a half, until last week. And this is what we're talking about for a few moments. If you're not familiar with it yet, this is a decision that was issued by Vice Chancellor Laster, where he found, and it never really had been held, although I think many people expected this would be the outcome, that caremark liability can apply to officers, not just directors. And it's a circumstance where the HR officer within McDonald's was sued under a caremark claim concerning the company's sexual harassment issues and workplace environment issues that occurred, including sexual harassment issues concerning that individual officer himself. Moved to dismiss. In a 12b6 ruling, I'm going to explain why that's significant in a minute. Vice Chancellor Laster looked at the law and said, first of all, Delaware law has held for a number of years now, I think going back to 2009 Gantler, that officers have the same fiduciary duties as directors, so why shouldn't oversight claims apply to them? Seems logical. That officers have an agency relationship with boards, and agency relationships themselves are fiduciary nature, so why shouldn't it apply? Bankruptcy courts, I think because 23.1 never applies in bankruptcy court, had been applying caremark claims to officers for a number of years, so why shouldn't it apply? Anyway, he gets to the conclusion they should apply to officers. The standard is the same that he applies for ultimate liability, is the same as for directors, which is the bad faith standard. There's a discussion of why. I'm not going to take time on that. What I think is interesting, though, about his holding here is what's going to happen, because officers are in a different spot, and so as a legal matter, a big issue is the scope. What's the scope of it? Directors have full remit, to use the word the court used, over everything in the company. The CEO, certain officers would have sort of the scope of their duties might be company-wide, but for other officers it might be just more focused to their line obligations within what they're charged to doing. So there's the potential for a lot of law to, or a lot of litigation to occur in defining those scope issues, and they would be real issues if indeed those cases proceed. And one of the reasons I'm not so sure they will is because this was ruled on 12b6 grounds, and the typical situation in a caremark case is a Rule 23.1 defense, which is that it's a derivative case. You have to demonstrate that the board doesn't have sufficient independence to handle the claim itself. He didn't rule on that ground, and I think you'll find, and that defense will still exist for all officer cases that may come down the line that relate to officers. So what I think may be a likely consequence is that many of these cases will follow the typical pattern of being dismissed, unless you have some pretty extraordinary facts that would taint enough people on the board, and that this then becomes an issue internally within companies that are going to have to examine these claims after that dismissal, because it just shouldn't just go in a dustbin. The company then needs to sort that claim out itself. And that may be the context in which some analysis of the scope of people's responsibilities and so forth really occurs, not necessarily the courts, but we'll see.
And maybe we see boards of directors get more demand letters insisting that they sue officers. And
yeah, it's true. Absolutely. I can see that happening easily. Yeah.
Which could be very interesting.
I'm just going to take 1 second on this. I think up there. Everybody always likes to, I know there's big concern on the defense side about 220 really run amok, and now emails, tweets, whatever it may be, can even be produced in 220. So I just wanted to highlight two decisions from last year. So on the left, it's sort of what to do, and on the right, what not to do. On the left, I think people who have good record keeping, good minutes, and when I say good minutes, I don't mean cursory minutes or just action taken minutes, but minutes that actually give enough narrative about the subject matter of what's involved, particularly in an M&A transaction. You can be rewarded that it will be kept. A 220 request can be kept at board level documents, not go to officer level documents, not necessarily go beyond sort of core documents, the minutes, the key things the board sees, its presentations, and getting to emails and so forth. And that's sort of the point from the Amazon case there. On the other hand, what not to do is on the right-hand column, which is you're basically dead if you're going to have inconsistencies or contradictions between your minutes and your proxy statement or your public filings. Now, most background transactions come right out of the minutes, so you really shouldn't have inconsistencies. But if you do, you're going to have a problem. So that's sort of the what not to do column of these two cases. What are we talking about now? Am I done on my slides? Or?
Yeah, why don't we jump
Okay.
we'll jump to just quick closing. I think we've got 3 minutes left, and I'll give a form of multiple choice question to the panel. You can answer either or both, but only proviso is you do it in a few words. What do you think the biggest shareholder litigation threat facing companies is in 2023? And or, if you were king or the supreme ruler, what Supreme Court decision would you reverse in the investor litigation area or civil litigation area, whether it be the U.S. Supreme Court or the Delaware Supreme Court?
Am I going first?
You're first.
I'll take the second door, and I'd say any of the 3 cases in which I was reversed, I would like those reversed. And I'm happy to go through each of them, but I'll skip that. There's actually one that is a pet peeve of mine, and it takes. Can I have more than 5 seconds?
You sure
All right,
can.
So do it in 1 minute. In Delaware, the court chancery is like 7 judges right now. We also have masters, and the masters do such great work for the court. But the problem we have with masters is that we have this case called D. Jacoby versus Sestak, which from a number of years ago, when purportedly one member of the Supreme Court had a little tiff with a former master, they instituted de novo review, not just of legal rulings, but of all factual findings that a master makes that handles the case. Because the master's cases can be, exceptions to a master's case can be taken, or a decision can be taken to a member of the Court of Chancery. That I'd like to reverse because, and the analysis was they're not, constitutional judges under Delaware law, therefore they're different, so on and so forth. But we have really good masters. It would be so much more efficient for there to be deference on factual findings. And I'll just give you 30 more seconds on that. One of my very first cases, I think somebody assigned, Chancellor gets assigned all the cases, including cases to him or herself. And I think somebody assigned a real bad case to me right when I walked in the door, which is exceptions on a master's report about a little piece of land that most people would never want to own in Felton, Delaware. And there was a 5-day trial, and it was all fact-intensive. So what I had to do is spend 5 days watching a video of the entire trial because I couldn't defer the factual findings. And it was all fact-intensive about sort of testator intent with a will. So that is the one I'd like to reverse.
Hopefully they're listening. That
Yeah,
sounds
yeah.
compelling to me. Darren, John, quickly.
I think for me, it's just, you've now had 2 25 basis interest rate increases, 250 and 475s in a 1-year period. The implications of that, there's going to be serious fallout for those holding fixed income instruments and things tethered to that. It's going to be dramatic. We haven't had this in 40 years, so that's coming.
So I'm going to take the Supreme Court one. When Adam said this, he said and emphasized has to be in the securities field. You don't get to pick another decision from last term of the Supreme Court. I would either reverse Lorenzo or Janus. I think they're completely inconsistent with each other. Janus says only a maker of a statement can be liable under 10b-5, and Lorenzo says, well, not so if somebody else distributes it. You could have scheme liability without Lorenzo. One of them has to be wrong.
Well, John, that's remarkably objective. As a defense lawyer, I'm just going to say Lorenzo. Thank you very much.